Hi, in this video, we are talking about something that can make or break a business, keeping secrets safe. I'm talking about non-disclosure agreements, NDAs, the backbone of confidentiality in businesses, employment, and even media houses. But drafting an NDA is not just about plugging in a template. You need to ask the right questions to ensure your NDA is airtight, valid, and protects your client's interests optimally. So let's break it down. An NDA is a legally binding contract that protects sensitive information from being leaked. Now, these are the three types of NDAs. First is unilateral. Only one party is bound by confidentiality, for example, employer employee. Then there is bilateral, that is mutual. Both parties are bound, for example, business partnerships, and multilateral. More than two parties are involved, all bound by confidentiality. Now, before you draft an NDA, here are 10 crucial questions you must ask your client. Question number one: what is the nature and purpose of the NDA? Understanding the nature and purpose of the NDA is crucial. Is it unilateral, mutual, or multilateral? What kind of information is being protected? Trade secrets, proprietary data, personal privacy? Knowing this shapes the fundamental structure of the NDA. Choose the right type of NDA based on your client's needs to ensure optimal protection. Next question is, what constitutes confidential information? An NDA is only as strong as its definition of confidential information. Now, say for example, there's a bad definition, all business information. Now, this is too broad and unenforceable. On the other hand, you have a good definition, includes but is not limited to business plans, financial statements, client lists, marketing strategies, product designs, software source code. Now, be precise yet comprehensive to ensure clarity and enforceability so that it specifies what needs to be confidential. Third question is, who are the parties involved? Who exactly is involved in the NDA? Are there subsidiaries, affiliates, or parent companies that also need to be covered? If your client is dealing with a large corporation, should the NDA apply to the entire group or just a specific entity? Clearly specify all entities involved to avoid loopholes. Question number 4. What are the obligations of each party? The NDA should outline who does what. The receiving party must protect the information, restrict access, and prevent unauthorized disclosure. The disclosing party should label confidential documents and provide information securely. So, clearly define obligations to prevent misuse and legal gray areas. Now, question number 5, are there any exceptions to confidentiality? Not everything can be classified as confidential. Common exceptions include information already public before signing the NDA, information legally required to be disclosed, for example, subpoenas, then information independently developed without using the disclosed data. So make sure these exceptions are clearly outlined to avoid future disputes. Now, question number 6 is there a non-compete clause? Non-compete clauses prevent the receiving party from using confidential information to compete directly with the disclosing party. The key elements here are received activities. So, what exactly is prohibited? Geographical scope, local, national, or global restrictions. Then, time frame. How long does the restriction last? So, clearly define boundaries and duration to keep the non-compete enforceable. Question 7. Does the NDA include a non-solicitation clause? Does your client want to prevent the receiving party from poaching employees, clients, or suppliers? Define who cannot be solicited. Employees, vendors, clients. Set a reasonable time frame, for example, 1 to 2 years post agreement. Specify clear restrictions and time frames to make non-solicit clauses enforceable. Now, eighth question is, how long should confidentiality last? How long should the confidentiality obligation last and to be followed? Standard NDAs last 3 to 5 years but can vary by industry. So set a time frame that balances business protection with legal feasibility. Now, ninth question, what happens after the NDA ends? What happens to confidential data when the NDA expires or is terminated? First is return. The receiving party hands back physical and digital files. Second is destruction. Secure deletion or shredding of confidential data. Always specify the post NDA process to prevent misuse of data. Finally, the 10th question is, what are the remedies for breach? What happens if someone violates the NDA? First is injunctions, court orders preventing further breaches. Second is liquidated damages, predefined monetary penalties. Third, legal cost recovery. The breaching party covers the legal fees in this case. Clearly defined penalties and consequences to deter breaches. Now, NDAs are essential in protecting sensitive information, but drafting them correctly requires precision and legal foresight. Do you want to learn how to draft powerful, enforceable NDAs and much more? Join our free 3-day online bootcamp where we cover how to draft NDAs that hold up in court, common mistakes and how to avoid them, how to negotiate NDA clauses effectively, and much more about contract drafting skills. This bootcamp is live, there'll be no recordings available, so I'll see you at the bootcamp live.